We thank you so much for watching Law School Made Easy at Law School Made Easy 256. I want to urge you members to subscribe to our channel. Double check if you have subscribed and you be a part of our channel. I want to discuss section 11, so section 12. Section 12 of the Evidence Act, which we call under the res case tie. So, colleagues, facts when right or custom is in question. Fact when right or custom is in question. This is what we want to discuss, and we try to appreciate it. Where the question is as to the existence of any right or custom, the following facts are relevant. Any transaction by which the right or custom in question was created, okay, claimed, modified, recognized, asserted, or denied, or which was inconsistent with its existence. Particulars instance in which the right or custom was claimed, recognized, or exercised, or in which exercise was disputed or asserted or departed from. Now, members, we are discussing culture and rights. Okay? I want to urge members to interest yourself in the case of Cooper. I think Elijah Cooper versus A and others versus AG. Then the case of Bruno Chihuahua versus Ivan Serunkumba and the Namazi Judith. That case, I may mix up the names, but I think there is a Chihuahua, there is a Serunkumba and a Namazi in that case. Now, members, when we are discussing culture, right or custom, first and foremost, custom does not only mean that you must discuss customary, no. Custom can be usage in an area. The Land Senior Council, Bachide, one time he gave an example that people in Senior Council Bachide is my senior, one of the senior lecturers. One time he gave an example that people in Chikobo have their way of living life. You come in the morning, you tell a colleague in a shop, give me 100 million, I will turn in the evening. Give me 100 million, I will turn tomorrow. Give me 50, and people would exchange money there. That is their custom. So if we have a dispute that arises at the time, okay, now we must determine that custom in court. So the act is saying we need the people who were in special positions, people who know about that custom, when it was created, when it was recognized, when it was asserted. Those people who have a knowledge about that custom will come and determine and give us those facts. When we have people who are acquainted to that type of custom, then those facts should be relevant. Then when you look at right, is there a right being denied? People tend to think that this section 12 only talks about custom. But we are talking about a right. Is there a right which has been denied? Okay, that right, was it created? Was it there? Do people know about it? If that right is now denied, then it comes into question. People who know about that right, okay, when that right was created, when it was claimed, when it was modified, when it was recognized, asserted, or denied, you should come up and tell us. So their facts would be relevant. About rights, read about the guns in Karamoja. Read that case of Okupa and very many others versus AG. It will show you that the government had a right. People had a right to live well. Now, if you deny them a right of living, it becomes a challenge. Look at that case we discussed in constitutional history. Tadis versus Bombay Municipal Council. Right of life, right of living. If you take away their right, if you are negligent about their right. So people who know this right, if they come and rise up, those facts they are telling us will be relevant facts, and court will allow them in. Okay, then we are looking at culture, customary culture. If a culture ever existed, people who know about its existence, people who saw when it was modified, it was created, recognized or denied, when they come up to talk to us, we shall take their facts as being relevant facts. You have that case of Bruno Chihuahua, where Chihuahua, the father of Senukuma, was saying, these people cannot get married because I am a Muganda, I've lived in the Buganda culture, and because of that, they cannot get married. In Buganda, people from Ndiga clan cannot marry those of Ndiga clan. It is coming from somebody who is believed to have special knowledge, to know about this custom. Then all those facts should be relevant facts. But I wanted to make this clear. A custom can be a usage. A custom can be culture. And then we have a right under this article. So we have that case of Bruno Chihuahua and the case of Elijah Cooper and very many others versus Attorney General. It brings out, I stand to be guided if I have talked the wrong name in terms of Elijah Cooper, but it must be Elijah Cooper. I'll cross check and I'll put down in the comment section the case of a customary. So look at that case about rights and the other cases to clearly bring out the element of customary. Now, if you look at this custom, if you go to here, say section 30, part D, should be part D. Section 30 should be part D. Let me look for it here. Yes, part D. It is almost the same. It is discussing the public right, custom. So you will find that the case you use under this, you need it for hearsay under section 30. 30 party D also talks about rights. Okay, so but the most important is people who know when the right was created, people who know when the right was claimed or the custom was claimed, people who know when the right was modified, people who know when that right or custom was recognized, people who know when that right or custom was asserted, and those who know when it was denied. Those facts, when given to court by those people, then that would be admitted in court. So that is section 12, which talks about customs and rights. We have ably discussed the cases in there. So our next video, we shall discuss 13, 14, and then finally 15. Then we shall cross to hearsay, confessions, admissions, character, and that will be the end with evidence law. So we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, cheers.